we are very happy to introduce today's topic and speaker here to speak about bankruptcy through the lens of federalism is Selwyn D. Whitehead. Welcome, Selwyn.
Thanks so much for inviting me, Aaron, and I hope everyone is doing well and having a great week. I'm going to go over a few topics this afternoon. Introduce bankruptcy and give you an overview of what types there are, the key players and key events. And then we're going to talk about how bankruptcy intersects with federalism. And then I thought it would be interesting to introduce a few topics that are special issues in bankruptcy. That is to say, how it might be possible to discharge taxes, which are typically not discharged in bankruptcy, student loans also, and then some foreclosure intervention and prevention strategies, both for forward mortgages and for reverse mortgages. We have such a large senior population that have or will access reverse mortgages as a source of funding to fund their retirement. So, what is bankruptcy? So, what's up with it anyway? Bankruptcy 101, as I like to call it. That's the whys and the hows of bankruptcy and what it multiple functions it performs in our modern day capitalistic economic system. Well, it should be clear, unfortunately, as often happens in a worldwide or nationwide economic turndown, or even a specific turndown that affects only a particular individual or his or her family or his or her business, individuals, companies, and governments may find themselves in a position where they're unable to pay their debts, either as they come due or maybe even ever. This situation is also known as financial distress. And where debts are large enough, they can create great economic harm and hardship for the debtor. Sometimes this financial hardship is caused by the debtor, him or herself, such as through making improvident financial decisions. And sometimes it's not the debtor's direct fault, such as an unanticipated medical expense that's not covered by their insurance, or a divorce where multiple households must now be supported by the same pre-divorce income levels. And or it could be as a result of misplaced trust in a business associate or employee who commits embezzlement, or as a result of a vindictive person with control over the debtor's means of making a living, or just plain bad luck in the marketplace of ideas. Or it could be as a result of a pandemic that shuts down all non essential businesses in order to save lives. And this results in financial distress, not only for the business owner, but also for his or her employees. Now, regardless of the cause of this distress, in such cases, our law provides a remedy that is spelled out in Article 1, Section 8, Clause 4 of the United States Constitution, which charges our Congress with developing uniform laws on the subject of bankruptcy, as currently manifest by the United States Bankruptcy Code and the Federal Rules of Bankruptcy Procedures, along with the appropriate federal and state statutes and case law. Now, bankruptcy is a legal procedure that can be used by individuals and sometimes families, husbands and wives, or domestic partners. It can also be used by companies and by governments who that are insolvent. That is to say, they're not able to pay their debts when they come due in accord with the contractual agreement that they signed with their lender, or in the instances of legislated mandated payment agreements for governmental entities. Now, bankruptcy allows a debtor to be released from having to pay some or all of her debts in exchange for the turnover to a court appointed trustee and the liquidation thereafter of the debtor's non-exempt assets in this orderly distribution to her creditors, or the payment of the fair market value of these assets over time through another flavor of court-appointed trustee, or the debtor, him or herself, through a plan of reorganization that's approved by a bankruptcy court. However, bankruptcies can also be used by individuals, companies, and governments who may be solvent on paper, but may just lack the liquidity to pay their debts as they come due. And in the case of a solvent but illiquid debtor, a bankruptcy can be used to gain the time necessary to create this liquidity, either through negotiating a contractual arrangement with the creditor or by selling certain assets under the protection of the bankruptcy court that will provide that liquidity. Now, when a person or organization initiates a bankruptcy procedure, we say they file a petition in their local bankruptcy court near the business headquarters or one of the chief sites where the business operates, or if we're talking about individuals, where they reside, close to where they reside, the county general, or okay. And they're asking the court to place the debtor under the protection of the bankruptcy court. Now, when the case is a Chapter 7, a liquidating case, the debtor will gain quick and orderly access to liquidating her non-exempt assets to this court-appointed trustee while keeping her exempt assets to underwrite her fresh start. Or in the case of a Chapter 11, 12, or 13, these are reorganization cases. The bankruptcy filing places the debtor under the protection of the court to give the debtor the time to come up with a plan of reorganization wherein she will maintain control of her assets, such as a business asset or her house that might be in foreclosure, while paying what the court believes is a reasonable amount back to her creditors. Now, this chance to discharge debt legally and ethically is unique and it's a crucial part of our economic system. To understand why, we only need to consider the alternative. That is to say, let's consider what happened to debtors who were unable to pay their debts before bankruptcy was invented. It meant a loss of their freedom in debtor's prison, and in some economic systems and cultures, it could mean the loss of limb or life and their families ending up in debt servitude for the rest of their lives. So, who are the key players in this bankruptcy process? Well, they are the debtor or debtors, and that is to say, the real or artificial persons or people or persons or legal entity or entities that find themselves in financial distress. And then the next class are the debtor's creditors. And these are real or artificial people or persons or entities to whom the debtor owes money or some form of value. And then there's the debtor's attorney. Hopefully, the debtor has an attorney. And this is an individual or firm who is a fiduciary of and an advocate for the debtor or debtors, who is hired to assist the debtor in running the gambit of the bankruptcy process. And sometimes it really is a gambit. And then there's the creditor, and usually there's multiple creditors and their attorneys. And that is to say, the individual or firm that is a fiduciary and advocate for the creditors and is hired to assist the creditors in collecting as much of the creditor's outstanding balance due as is legally allowed. And sometimes, from my perspective, as mostly a debtor's counsel, they just seem to come in to muck up the work in order to get the debtor's case dismissed or have the stay shielding the debtor's assets and have that shield brushed away by getting the automatic stay lifted. Then the next key player, and probably should go first, but I'm listing them in order of what usually happens in the case. But the next key player is the bankruptcy court itself. And it's divided into three distinct entities from my vantage point. There's the bankruptcy judge, who is an Article 1 judge, who is impaneled by the Federal District Circuit Court and appended to the local federal district court. An Article 1 judge is a judge created by Article 1 of our Constitution, which is the Congress, as opposed to an Article 3 judge that's an entity that's subtending to our Supreme Court. Okay, then there's the judge's staff. The judge's staff helps the judge research and analyze the legal issues that are brought forth in the debtor's case. And then there's the clerk of the bankruptcy court, the specific court. And this individual and his or her staff, they're charged with performing the administrative and technical functions of the court. The next key player is the Office of the United States Trustee, and him, her, a subunit of the Department of Justice, whose job, along with other officers of the court, including those who practiced before it, and our job is to police the bankruptcy process and maintain its integrity. And the Office of the United States Trustee recruits the various kinds of trustees that are going to be needed in this process and also appoints them. And those trustees include a Chapter 7 trustee in a liquidating case, a Chapter 12 trustee in an individual or entity with regular income, of which at least 50% comes from the businesses of farming and or being a fisher person. And then there's a Chapter 13 trustee in an individual with regular income bankruptcy case. And there's a Chapter 11 trustee or the debtor in possession, him or herself, in a business or some individual cases that have a substantial amount of debt that precludes the use of Chapter 13. Then there's a new kid on the block, a Subchapter 5 Chapter 11 trustee that is appointed in cases that are geared towards reducing the expense of a regular Chapter 11, which can be very expensive, and by hopefully expediting the process and eliminating some of the requirements for a very small business debtor. And then the final individual who may or may not be involved in a case is an examiner, who is sometimes appointed by the court to ferret out the truth about the debtor's finances and or management of her business when there is an appearance of some kind of impropriety or some kind of mischief going on behalf of the debtor in possession in a Chapter 11 case. So what are the key generic events that happen in a bankruptcy? Well, there's the filing of the petition, and that institutes an order of relief and creates a bankruptcy estate containing all of the debtor's non-exempt assets. And so this order of relief is it's a shield. It's the Starship Enterprise's shield that comes up immediately when they sense the Klingons about to fire upon them. So this order of relief might not be known to anyone at its institution, but it's there. And again, it creates this bankruptcy estate that's protected and also creates an automatic stay. And immediately upon filing, an automatic stay goes into effect, halting most collection activities against the debtor. So we'll put a halt to a foreclosure, or say a business debtor, there's a judgment and the sheriff is coming to take its business asset. That's all stops. It doesn't stop permanently, but it stops at least temporarily while things can get sorted out. And then there is the appointment of the appropriate trustee. And the next in line, hopefully the debtor has filed all of her documents at the time that she filed the petition. Otherwise, there's a short time for her to get all those documents in place, so the trustee can review them before the Section 341 meeting. This meeting is also known as the meeting of the creditors, where the debtor is questioned under oath by the trustee and creditors about the debtor's financial position and what caused the filing in the first instance. Also, there's the claims filing process. Claimants in certain cases have a drop dead date by which they must file a proof of claim, and it establishes their right to receive a distribution from the bankruptcy estate based on some pre-existing relationship with the debtor, usually borrowing money or some kind of contract that's in place at the time of the debtor's filing the bankruptcy. Then the next step in a reorganization case is the plan development the circulation of that plan, and hopefully the confirmation of a plan in chapters 11, 12, and 13. These are, again, are reorganization cases, and the debtor, as part of her plan, proposes a repayment process, but it must be confirmed by the court after her creditors and other real parties in interest have an opportunity to review the plan and voice any objections to it. Okay. And in a liquidation case, a Chapter 7 liquidation case, the next step involves marshaling the debtor's non-exempt assets and the Chapter 7 trustee selling them in order to create a pool of funds to pay not only the Chapter 7 trustee and her staff, but also pay the creditors on this waterfall basis. Another aspect of the case is the other objections and potential litigation. So parties may file objections to proof of claims. So that would be the debtor saying, well, no, I didn't, this is a bogus contract that you're putting forth saying that I owe you money. Or the Chapter 7 trustee may file it because she is standing in the debtor's shoes. There also might be fights over exemptions. The debtor might say that I'm entitled to 10,000 exemption for my automobile, but maybe in California, that exemption is only $7,500. So there's over exemption value. And then the dischargeability of debt. Some debts are not dischargeable out of hand. And if a debtor wants to get them discharged, he or she will have to institute an adversary proceeding, for example, a student loan debt. Okay, then the next step, after the debtor has completed a plan, or shortly after the in a Chapter 7 case, 2 or 3 months after the case is filed, the debtor will get a discharge, releasing the debtor from her personal liability for certain kinds of debts, mostly her unsecured debt. And then the case is closed after all the proceedings are complete, and the trustee will file a final report explaining who, what, why got distribution, so forth. And again, these events can vary depending on the type of bankruptcy file, that is to say, a Chapter 7 versus a Chapter 11 versus a Chapter 13 versus a Chapter 12. So next, we're going to take a look at federalism. Just how does bankruptcy intersect with federalism? I'm a big fan of federalism. I just thought I'd throw that in. So what is federalism, or why and how bankruptcy performs multiple functions in our modern day capitalistic economic system? Well, federalism is made manifest here in the United States, where we, the people, by proxy at the founding of this great nation, had and to this day still have multiple sovereigns. Now, according to Cornell Law School, at its website located at law.cornell.edu, sovereignty is a political concept that refers to a dominant power or supreme authority over an entire cadre of subjects or a subsection of subjects. I'm talking about we the people. Now, in a monarchy, supreme power resolves in the king or the queen as sovereign. In modern democracies such as ours, sovereignty rests with we the people and is exercised through our fairly elected representative bodies such as Congress, in concert with a likewise fairly elected chief executive, our president here in the United States, or a prime minister and a parliament who, while not the sovereigns, but are the heads of government in nations that were or remain part of the British Commonwealth. Now, under federalism, the same geographic territory is controlled by two and sometimes more level of separate and distinct governments. Generally, an overarching national government is responsible for broader government territorial areas, while smaller states and their subdivisions, that is to say, counties and cities within states, govern local issues. Now, both the national government and the smaller states and their political subdivision have the powers to make law, and both the federal and state governments have a certain level of autonomy from each other. Now, this is not true for cities and counties because they're subdivision of states, and the states are the supreme authority on the state level. Now, in the United States, as part of our Constitution, we established this system of dual sovereignties under which states have surrendered many of their powers to the federal government, but also retained some of their sovereignty. And an example of this is outlined in our Supremacy Clause. That's at Article 6 of the United States Constitution. And it reads, the Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and judges in every state shall be bound thereby. Anything in the Constitution or laws of the state to the contrary, notwithstanding. So this effectively means that when the laws of the federal government are in conflict with the laws of the state's government, the federal laws supersede them. So, for example, Article 1, Section 8 of the United States Constitution describes the specific powers which belong to our federal government. These powers are referred to as the enumerated powers. For example, the bankruptcy clause found in our Constitution at Article 1, Section 8, Clause 4 grants to Congress the authority to make uniform laws on the subject of bankruptcies throughout the United States. And so why do we need that? Why do we need Article 1, Section 8, Clause 4? Well, it was included in the Constitution to establish uniform system of bankruptcy laws throughout the United States would prevent our individual 13 original colonies that under the Articles of Confederation sometimes had conflicting laws. So this uniformity under Article 1, Section 8 prevents states from enacting conflicting or biased insolvency statutes that would disrupt our national economy. Now, this inclusion was driven by the economic realities and the political context of the time, which highlighted the need for a standardized national approach to address debts and bankruptcies consistently across all the original United States. So the key to Article 1, Section 8, Clause 4 are uniformity and state sovereignty. The framers of the Constitution intended to prevent individual states from implementing their own disparate bankruptcy laws, which could lead to uneven treatment of debtors and creditors across state lines. Now, this was particularly important in an up-and-coming yet nascent nation where interstate commerce was vital, a vital component of its growth. The inclusion of bankruptcy laws in the Constitution allowed for the uniform system that states had to adhere to, thus ceding their sovereignty in these matters of insolvency, to the Constitutional Convention. It also, this article, the bankruptcy clause, it leads to economic stability and fairness under our system. The framers recognized that having different bankruptcy laws in each state could lead to injustices and economic instability, as states might favor their own citizens or their own creditors, thereby undermining the cohesive national economy. So Congress hoped that this particular clause would ensure fair treatment of all parties and maintain economic stability. It was also deemed necessary to prevent state discrimination and abuse. Again, historically, states had and might continue to enact laws that would discriminate against out-of-state creditors and create favorable conditions for its own residents, which would lead to abuses. Again, the bankruptcy clause was intended to prevent these scenarios. And finally, it was concerned with jurisdiction and how it was going to be implemented. The Constitution provides Congress with the authority to enact bankruptcy laws that must be uniform, thereby ensuring that laws equally apply in all states without being influenced by local conditions. So the key points of these processes illustrate why the framers included the power to legislate bankruptcy in our Constitution, again, emphasizing the importance of national consistencies when dealing with and managing bankruptcies and insolvencies. So, how does it work? Well, here in the United States, we have one federal government and 50 independent and mostly autonomous state governments. The vast majority of subtending, again, the subtending local governments adhere to the state governments. Now, sometimes by accident or design, these multiple layers of sovereign act in unison, but mostly they do not. But in our particular form of government, our federalism, when observed through the lens of bankruptcy, in our economic system, in my opinion, it reflects the melding of these separate and distinct sovereigns to create a unity of debt relief process for the public good, again, in accord with Article 1, Section 8, Clause 4 of the Constitution. I say this because it's been my observation on most of the occasions that I have participated as a lawyer, but unfortunately not in all, but in most, I have witnessed when when led by a fair and open-minded judge, a well-run, fair and equitable bankruptcy court system can be held up as a prime example of the hopes and aspirations of federalism. This because the interdependent nature of bankruptcy court function when the system worked properly manifests the melding together of the various distinct parts of our Constitution at the federal level with the legitimate rights and powers of our individual state legislators when empowered by their individual state constitutions to create statutes and case law concerning the legal relationships between honest debtors and honest creditors that are used to govern the conduct, rights, and responsibilities of we the people who live mostly in states and seek protection of the bankruptcy court to obtain a fresh financial start when we fall on difficult financial times, while treating our honest creditors fairly and equitably in accord with our multiplicity and interdisciplinary laws about the debtor-creditor relationship. So let's visualize how all these concepts come together in a fairly administrated bankruptcy process. So I've drawn my stick figure called Ms. Bankruptcy Court. And please excuse my I guess first grade level of drawing, but it will suffice for my point. Now, Ms. Bankruptcy Court is facing us. So if she has a big round head that's divided into quadrants representing the working parts of her bankruptcy brain. On the upper left facing quadrant, I have entitled it as Article 1, as it represents Article 1, Section 8, Clause 4 of the Constitution, and that's drafted and defined and updated by Title 11 of the United States Bankruptcy Code to deal with bankruptcies. As such, it is the mama and papa of the bankruptcy court. Now, in the upper right facing quadrant, I have entitled it as Article 2, as it represents Article 2 of the United States Constitution, or the executive branch. And I have it listed here because it is through that executive branch, through the Department of Justice, resides the Office of the United States Trustee, whose function is to oversee the running of the legal and administrative functions of the bankruptcy process, and hopefully do only those things that maintain the integrity of the bankruptcy process. Now, the lower left quadrant I've identified as Article 3, as it represents Article 3 of the United States Constitution, or the judicial branch, which is responsible for the creation and modification of the federal rules of bankruptcy procedure, which instructs the bankruptcy court, although not a creature of Article 3, but because it is a creature of Article 1, Congress, nonetheless, it's appended to a local federal district court and must follow the rules laid down by Article 3 courts in accord with those promulgated by the United States Supreme Court. And then the lower right-facing quadrant represents the Bill of Rights of the United States Constitution, including the most predominantly in the bankruptcy context, the Fifth Amendment's taking and due process clauses on the federal level, and the 14th Amendment due process clause on the state level that require bankruptcy courts to adhere to the dual mandates that require that federal or state governments, when dealing with creditors' rights, such that these governments not take property from creditors, even where that property is needed to discharge some or all of the debtor's unsecured debt necessary to advance the public policy goal of bankruptcy that allows debtors to obtain the fresh financial start. Again, only if she or he, the debtor, is an honest but unfortunate debtor. It is inherent in the bankruptcy code, which this idea of not taking from a creditor, unless this creditor is provided with just compensation under the circumstances and always receives adequate notice of their, that is to say, the creditor's right to participate in the bankruptcy legal process, such as the creditor will have a fair opportunity to bring forth his or her legitimate challenges to the debtor's rights to seek and maintain protection of the bankruptcy court in the first instance. So moving down the body of Ms. Bankruptcy Court are her two outreached arms. And they are balancing the rights of the debtor on her left-facing arm while balancing the rights of the debtor's creditors on her right-facing arm. Now, some of the major issues that come to fore in balancing this balancing act include for the debtor, obtaining and maintaining that automatic stay for the duration of the case, challenging a creditor's right to a distribution due to the debtor alleging that the filing of a proof of claim was bogus, and then ultimately obtaining a discharge from her unpaid portion of her debt at the end of the ordeal. And this is on the left-facing side of Ms. Bankruptcy Court. Now, as for the creditor's rights in bankruptcy are receiving adequate notice of the proceeding and an attendant opportunity to participate in the proceeding to protect the creditor's rights. Also, the creditor may, as I said before, seek to obtain an order lifting the automatic stay so that that creditor can continue that foreclosure process or that asset taking process that was stopped at the instance the order of relief was on the books. And also obtaining another issue that the debtor's creditors wants are an order that the debtor's debts are non-dischargeable. All these things are on the right side, right-facing arm of Ms. Bankruptcy Court. Then moving further down the body of Ms. Bankruptcy Court to her legs that represent the fact that she is standing in two distinct jurisdictions simultaneously while performing her function as the arbiter of the state and federal laws of debtors and creditors pursuant to and in furtherance with the Federal Bankruptcy Code and the Federal Rules of Bankruptcy Procedure. Again, facing me on the left leg is planted in the state and county where the debtor is located and has resided in for the required amount of time. As such, Ms. Bankruptcy Court must adhere to the applicable state constitution, legislation, and legal decisions of the highest court in the state when it comes to the laws of debtors and creditors created in that jurisdiction. And Ms. Bankruptcy Court's right-facing leg is planted firmly in the federal judicial district to which she has been appended and must now therefore follow the local rules of the district court and the case law in the federal circuit as to bankruptcy law and federal rules of bankruptcy bankruptcy procedures laid down by the United States Supreme Court. Now, you might say, why is this a big deal? In some instances, the bankruptcy court will bend to the will of the state court in some kind of debtor and creditor relationship. And you as practitioners need to know this, or you as individuals who want to do things pro se, you need to understand these sometimes dueling, but mostly adhering distinct parts of how federalism melds the law of the state and local government with the federal rules of bankruptcy procedure and the bankruptcy code. Now, moving back up Ms. Bankruptcy Court's big head, I have drawn a big fat, well, it's not chocolate, but there's a nose on in the middle of her face to express the deliberative process where she analyzes all of the inputs from the United States Constitution in her brain and then balances the rights of the debtors and creditors in her upper extremities, and also reviews the state law and rulings of the highest state court where the event initiating the debtor-creditor relationship took place, as well as the federal rules of bankruptcy procedures and the case law of the district and circuit where her lower extremities are physically located before she issues a ruling in a particular case. Now, what are some of the key functions of the bankruptcy in the United States, and how does it serve our modern day capitalistic systems? Well, the key functions of bankruptcy in the US serve important roles in supporting our modern capitalistic economic system. The primary purpose of bankruptcy and the bankruptcy code includes helping individuals and businesses achieve a fresh start by reorganizing or discharging some or all of the debt, which allows them to reorder their affairs and make peace with their creditors. So it's not like, the days of shootouts. We're going to make peace with our creditors, and the creditors are going to get on with their lives, and debtors are going to get on with their lives. This process not only helps relieve the pressures and the discouragement of pre-existing overburdened debt, but it also aims to preserve the ongoing viability and operations of businesses, including their ability to pay employees and pay taxes. One significant function is to allow a corporation to restructure to avoid liquidation. This restructuring process is vital as it aims to maximize the value of the bankruptcy estate for its creditors. By enabling the business to continue its operation, bankruptcy helps preserve jobs, maintain suppliers and customer relationships, and it generally supports the economic stability of the community and our broader economic viability as a nation. Now, bankruptcy also addresses the collective action process. So if you didn't have bankruptcy, the first creditor to not be paid on time would rush in and sue the debtor and get as much of the debtor's assets as possible. That would mean the second, third, fourth, and 100th creditor might not have anything. The bankruptcy process, when used properly, will stop that eating away of the debtor's assets by the first to go to court. And there's ways to claw back some instances where the first to go to court and gather all of the debtor's assets. There's ways to claw that back in bankruptcy, but that's a topic for a more advanced course. Okay. Again, bankruptcy also facilitates the equitable distribution of the bankruptcy debtor's assets, ensuring that all creditors are treated fairly according to the priorities that have been established by law. So in summary, the United States bankruptcy court system supports the capitalistic economic system by helping distressed individuals and businesses clear their debts and continue their operations, enhancing the asset recovery and distribution for their legitimate, honest creditors, maintaining employment, and stabilizing our economy. So the next thing I want to talk about are some special issues in bankruptcy. And I want to talk about three. If you are a bankruptcy counsel and a particular debtor comes to you with taxes, they might not have filed their taxes. They might have filed their taxes late. They might have filed their taxes and not paid their taxes. I want to pinpoint a couple of particulars there. And I also want to talk about another instance that might come to the fore, and that's discharging student loan debts. And finally, I want to talk about foreclosure prevention and intervention strategies that might come to the fore. So some say you can discharge taxes in bankruptcy. Well, that is not an adequate statement, an accurate statement. To discharge taxes in bankruptcy, several key requirements must be met based on the applicable provisions of the Bankruptcy Code, particularly Section 523A and 507A. The primary conditions that must be met is the timing of the tax return filing. Tax obligations associated with returns that are due within 3 years prior to filing the bankruptcy are generally non-dischargeable. This includes late filed returns within 2 years of filing the bankruptcy. Also, there's an assessment period. Taxes assessed within 240 days before the filing of the bankruptcy petition are considered priority and not dischargeable. And the type of tax involved. For instance, tax penalties related to events more than 3 years before the bankruptcy filing are dischargeable, but recent penalties are not. Also, what's not dischargeable in bankruptcy are tax returns that were related to fraudulent activities or where there was an attempt to avoid paying taxes are also not dischargeable. So the failure to file a return when legally required to also will inhibit the ability to get the taxes discharged. And that means even where the government takes it upon itself to complete what it believes is a tax return without your help, that is not considered a tax return. So the problem here is you have to timely, so taxes that became due within 3 years of filing the case, that's 3 years before you filed, those are generally not dischargeable. Older taxes, maybe. So, if it was something, and the government has up to 10 years from when you file to go after you for taxes. So somewhere in between 3 and 10 years, maybe you can get the taxes discharged if all the requirements are met. Taxes that are older than 10 years, where the government has not done anything to extend that period, are likely can be discharged. So if you have taxes that are bringing you down, or your client has taxes that are bringing them down, you need to consult with a bankruptcy/tax expert to see if there's something that the bankruptcy process can do to assist that particular debtor. Okay. Now, again, these points highlight the nuanced nature of determining dischargeability of tax obligations in bankruptcy, focusing again on the timing of the tax assessment and filing, the type of tax and/or penalty, and issues around fraud and tax evasion. The next area that I want to focus on is student loan strategies in bankruptcy. Now, consumer bankruptcies exist to provide a fresh start for individuals in financial distress. However, the Bankruptcy Code prohibits discharge of an educational loan unless the debtor demonstrates through an adversary proceeding, that's a type of litigation, a type of federal litigation in bankruptcy courts, that the repayment of the debt would result in an undue hardship for the debtor and any of her dependents. Now, undue hardship is not defined in the Bankruptcy Code, and as a result, the standards and precedents for establishing undue hardship can vary considerably depending on the federal district in which the case is pending. Now, even in the most permissive districts, obtaining a discharge of a student loan debt is expensive and difficult. Historically, as such, relatively few debtors would even make an effort. Now, the elements or the requirements to show that there's an undue hardships is articulated in a case called Berner versus New York State Higher Education Services Corps. And it has three elements that test whether or not the debtor is facing an undue hardship. The first one is that the debtor cannot maintain, and based on the debtor's current income and expenses, a minimal standard of living for herself and her dependents if forced to repay these loans. Additionally, the second element is additional circumstances exist indicating that the state of affairs of the debtor will likely persist for the significant portion of the repayment period of the student loan. And finally, the debtor has made a good faith effort to repay the loan. Now, an adversary proceeding again is required as the forum for the debtor to articulate how she meets this criteria and for her opponent to challenge her veracity. Now, it involves filing an adversary complaint, and it's a distinct and subtending part of the overall bankruptcy case. Okay, and so after she files her complaint, it has to be properly served on her opponent. Okay, and the tests for whether or not undue hardship exists are as of the date of the trial. So if the case was filed on September 25th, 2024, and the trial for the case happens next year at this time, it's not the situation at the time of the filing of the bankruptcy case. It's the situation at the time of the institution of the adversary proceeding. Just as a highlight, this Bruner test is the majority opinion, and it has been adopted by the 3rd, 4th, 5th, 6th, 7th, and 9th Circuit that we are in, as well as the 10th and 11th Circuit. But there's a minority rule in the 8th Circuit, which is in the Midwest, which basically looks at something called the totality of the circumstances, which can be very, very hard to deal with. Okay, but wait, the cavalry might be coming, because the Department of Justice, in coordination with the Department of Education, issued guidance in November of 2022 that provides for a more expedited and I consider more fair way of coming up with a standard way to apply this Bruner test in a form that's readily accessible by the court and is signed off by the Department of Justice. And it has resulted in a large increase in individuals attempting to get their student loan debt discharged, with a very high success rate for those who try. So I want you to know, if you have clients that have student loan debt, and it's been, widely circulated in the media and throughout, parlance, that you can't get rid of student loan debt, but there might be a way. And so I would urge you to consult with a bankruptcy specialist who understands the ins and outs and can point you to some material that might help you address your client's student loan indebtedness. And again, it has to do with the Biden administration's coming up with, I know you heard about the Biden administration trying to, through executive order, or try to get Congress to do away with student loan debt. Well, and that hasn't succeeded because of certain Supreme Court rulings and others. But this is a process where the Department of Justice, in concert with the Department of Education, have come up with a streamlined version to prove or disprove that the debtor meets the requirements of the Bruner's test. And it is making things a lot more streamlined, again, because doing this as a federal litigation could be very expensive and time consuming, and it's mostly not work. But the downside of it, people don't even try, which is, I think, a sin and a shame. And then the final area that I want to touch on is foreclosure intervention and prevention strategies in bankruptcy. Now, foreclosure in California, that's where the trustee takes back property for the lender beneficiary, and the trustee sells the property at a trustee sale. If there's no buyers, the property will go into the lender's real estate owned portfolio. And the foreclosure process is based on the deed of trust that borrowers adhere to and sign off on. And it's a private trustee sale. And 90% of the foreclosures in California take place with this non-judicial foreclosure. It lasts about 120 days. The borrower homeowner has no redemption rights, and the lender has no deficiency rights. Now, judicial foreclosures are rare, but they're required in some instances, especially where we have an active duty military service person who is on the receiving end of the default notice. That matter has to be conducted judicially with the goal of making sure that our active duty service members' rights are protected to the utmost. Now, a judicial foreclosure is slower. It takes usually about a year or so to complete the process. So the process in California is their default. There's a notice of default with certain timeframes. So the debtor has 90 days to cure the default after the notice of default. And on the 91st day, the trustee, the lender, can issue a notice of trustee sale. And the best way to stop it, and sometimes the only way, is to file a bankruptcy. Then if there's nothing that would stop the sale will take place on the 21st day. And post-sale, the new owner receives a trustee's deed upon sale, and the buyer is ordered to get out of the property. The entire process takes about 120 days. So bankruptcy can assist by coming in and allowing the debtor to stop the foreclosure and have the time to cure the arrears as part of her plan of reorganization. It doesn't work in a liquidation case, but it might work in a reorganization case. So I wanted to also talk about special issues with reverse mortgages. Now, where a lender wants to foreclose on a reverse mortgage where the debtor's in default, you may say, well, how could a debtor be in default and a reverse mortgage? Because that's where the debtor is using her equity to create a pool of funds, either a lump sum payment or a monthly payment. So how can she be in default if she's receiving money from the bank? Well, it's because many homeowners are used to having their property taxes and their insurance paid for out of the payment that they make to their lender in a forward-facing mortgage. Well, that's not the case in a reverse mortgage. And sometimes, especially senior reverse mortgage borrowers, don't pay their property taxes, don't timely pay the property taxes. They don't pay their insurance timely, or they let it lapse. They don't maintain the property to the level that's required as part of their contract. And they can move out of the house, maybe to put someone in to rent it. But one of the requirements might be that they have to reside in the house during the terms of the reverse mortgage. All of those are reasons for default. And so that's why sometimes people will come to you to deal with a reverse mortgage. There are some key issues that I just want to point out to you that are different. And so how could a reverse mortgage be helped in a bankruptcy? They would get the automatic stay. The relief would only be temporary, but they would get the automatic stay. They could provide for the Chapter 13 to allow them to catch up on missed payments. Again, not mortgage payments, but insurance payments and or property tax payments. They also might have some additional debt that they incurred while they were in the reverse mortgage, unsecured debt that might be discharged in the bankruptcy. And it also gives them a forum to negotiate with the reverse mortgage holder to try to resolve the matter amicably or as amicably as possible. But there's some issues that the debtors need to know about before they file a bankruptcy. Again, the automatic stay is limited. The non-dischargeable debt, you can't discharge the reverse mortgage, and it may and likely will halt the payment of that funding that you applied for the first reverse mortgage in the first instance. Say the monthly payment in, they would stop. Or if you had not completed the large allocation of the funds, if you were going to get a lump sum payment, uh, or you were going to use a line of credit, only use the money when you needed it. All of that would be halted, and you needed to take that into consideration before you decide to proceed with entering into a bankruptcy while you had a reverse mortgage. Also, it will have a negative impact on the debtor's heirs. Um, uh, um, that you might want to bring them into the process to make sure that they understand what's going on. So with that, I'm sorry there was so much to give, but I wanted to leave a couple minutes for questions.
Thank you so much, Selwyn. That was super. We got a question here. Thank you for the question. Would like to know your personal experience with adversaries to discharge student loans in the Bay Area bankruptcy courts.
Well, I actually have had success, and this was even before the new guidelines. Um, uh, Again, it depends on the debtor's circumstances. Uh, but again, this new procedure where there's this fillable form that the Department of Justice has put together with the Department of Education. And if you can answer all of those questions, you and your client, it's highly likely that you and your client will know from jump whether or not it's worth your time and energy to file an adversary proceeding. But I have heard from my colleagues around the country that this new process is working, but so few people know about it and are using it. And it's just a shame because many seniors are tied down with their children and or their grandchildren's debt because they wanted to help their legacy go to college, and now they're in their old age and with limited income. And I think some of these people would be great candidates to get that student loan debt removed. So reach out to me. Oh, so all of you, my contact information is on the my headline, my there you go.
Yeah.
For the handout material. Hey, reach out to me, if you want some assistance, and I'm happy to point you in the right direction or give you some advice for what it's worth.
Uh, Again, thank you so much, Selwyn.
My pleasure. Take care, everybody.